everyone, welcome to Corporate Law Journal. Today we will discuss one of the latest landmark judgments of the Supreme Court, that is Messrs. Arif Azim Company Limited versus Messrs. Aptech Limited. In this case, the Supreme Court's division bench consisting of CJI Dr. D.Y. Chandrachud, Justice J.V. Pardiwala and Justice Manoj Misra ruled that the Limitation Act 1963 applies to proceedings for appointing an arbitrator under Section 11 subsection 6 of the Arbitration and Conciliation Act 1996. It further stated that a court has the discretion to decline a reference if, at the beginning of the arbitration proceedings, the claims appears to be time-barred. Before delving deeper, let's understand the factual matrix first. The petitioner, Messrs. Arif Azim Company Limited, also referred to as the franchisee, is an Afghan-based company that operates in computer education, IT, and English training, whereas the respondent, Messrs. Aptech Limited, also referred to as the franchisor, is headquartered in Mumbai, Maharashtra, and provides IT education globally. On 21st March 2013, three separate franchise agreements were entered into between franchisee and the franchisor. As per the terms of the said agreements, the petitioner, as the franchisee, was granted a non-exclusive license by the respondent to establish and operate businesses under the following trade names. First, Aptech English Language Academy, short for ALA. Second, Aptech Computer Education, short for ACE. Third, Aptech Hardware and Networking Academy, short for AHNA. The dispute in the present case pertains to the agreement entered into between parties for the ALA. Pursuant to the signing of the aforesaid agreement, proposals were invited by the Indian Council for Cultural Relations, short for ICCR, in 2016 for the execution of a short-term course for training in English for students from Afghanistan who were selected to pursue degree courses in Indian universities in the academic year 2017-18 under the scholarship scheme of the Government of India. The proposal of the respondent was accepted by the ICCR by its sanction order number SSSAN 2017-18 dated 10th October 2016. The sanction order prescribed the schedule for the conduct of the course, submission of progress report to the Embassy of India in Kabul, short for EOI Kabul, etc., and also approved the training fees at rupees 5,000 plus service tax per student per month. The order also stipulated that the payments for the course would be released to the respondent by the ICCR at the end of every month after getting an endorsement from the EOI Kabul. Following the sanction order, the respondent informed the petitioner via email dated 17th October 2016 expressing intentions to discuss implementation of the order once ICCR's expectations were understood. Subsequent email exchanges between the parties discussed course details, syllabus, trainers, etc. On 24th December 2016, EOI Kabul informed the petitioner that although Afghan student applications were submitted to Indian universities, admissions had not commenced. ICCR suggested starting the course in late January or early February 2017. From February to April 2017, the petitioner executed the course in Kabul for 440 Afghan students certified by EOI Kabul on 30th July 2017. Disputes arose regarding renewal and payment of royalties for franchise agreements signed in March 2013. On 20th March 2018, the respondent issued a recovery notice to the petitioner for non-payment of royalty or renewal fees. Email correspondence ensued, with the petitioner explaining course execution details and seeking payment details. The respondent claimed to have received only 61.5% of the claimed amount from ICCR after deductions. Discussions on non-payment ceased on 28th March 2018, but renewal discussions continued. On 23rd April 2018, the petitioner decided not to renew ACE and ALA franchise agreements due to payment dispute, renewing only AHNA agreement. After about 9 months, the petitioner raised non-payment issues again on 29th December 2018, requesting accounting details. Thereafter, a further gap of 3 years, the petitioner again took up the issue of non-payment of dues for the ICCR project with the respondent and sent a legal notice on 26th August 2021, demanding payment within 15 days, failing which legal action would be initiated. After 10 months, pre-institution mediation was attempted in accordance with Section 12A of the Commercial Codes Act 2015 on 5th July 2022, but failed. Arbitration was invoked on 24th November 2022 and respondent denied claims citing limitation. The petitioner filed the present petition on 19th April 2023 after respondent's failure to nominate an arbitrator. The case gave rise to the following two legal questions for examination. First, whether the Limitation Act 1963 is applicable to an application for appointment of arbitrator under Section 11 subsection 6 of the Arbitration and Conciliation Act 1996. If yes, whether the present petition is barred by limitation. Second, whether the court may refuse to make a reference under Section 11 of the 1996 Act where the claims are ex facie and hopelessly time barred. The plain reading of Section 11, subsection 6 of the 1996 Act, which provides for appointment of arbitrators, indicates that no time limit has been prescribed for filing an application under the said section. However, Section 43 of the 1996 Act provides that the Limitation Act 1963 would apply to arbitrations as it applies to proceedings in court. Since none of the articles in the schedule to the Limitation Act 1963 provides a time period for filing an application under Section 11, subsection 6 of the Act of 1996, it would be covered by Article 137 of the Limitation Act, which is the residual provision. It stipulates that the period of limitation would be 3 years in case of filing any other application for which no period of limitation is provided elsewhere in this division, and that the time period shall begin from when the right to apply accrues. In Geo Miller and Company Private Limited versus Chairman Rajasthan Vidyut Utpadan Nigam Limited, a 3-judge bench of this court outlined the parallels between sections 43 subsection 1 and subsection 3 of 1996 Act and sections 37 subsection 1 and subsection 4 of the 1940 Act, emphasizing that the limitation period for arbitration under both acts is 3 years from the date the cause of action arises. Further, this court in Panchu Gopal Bose observed that in mercantile references of this kind, it is implied that the arbitrator must decide the dispute according to the existing law of contract, and every defense which would have been open to the parties in a court of law, such as the plea of limitation, would be open to the parties for the arbitrator's decision as well. Therefore, the period of limitation for the commencement of an arbitration runs from the date on which, had there been no arbitration clause, the cause of action would have accrued. Just as in the case of civil actions, the claim is not to be brought after the expiration of a specified number of years from the date on which the cause of action accrued, so in the case of arbitrations, the claim is not to be put forward after the expiration of the specified number of years from the date when the claim accrued. An extension of time is not automatic, and it is only granted if undue hardship would otherwise be caused. Not all hardship, however, is undue hardship. It may be proper that hardship caused to a party by his own default should be borne by him and not transferred to the other party by allowing a claim to be reopened after it has become barred. Further, in Damodar Das case, this court observed, relying upon Russell on arbitration by Anthony Walton, and in Panchu Gopal Bose case, that the period of limitation for an application for appointment of arbitrator under sections 8 and 20 of the 1940 Act commences on the date on which the cause of arbitration accrued, that is, from the date when the claimant first acquired either a right of action or a right to require that an arbitration takes place upon the dispute concerned. After reviewing the statutory framework and case law, the court was confident that the Limitation Act 1963, specifically Article 137, applies to arbitration proceedings and petitions under Section 11, subsection 6 of the Arbitration Act 1996 in particular. Moving forward, the next issue up for debate is whether the current petition for the appointment of an arbitrator is time-barred. The application of the statute of limitations to a petition under Section 11, subsection 6 of the Act 1996 has been considered by Dr. P.C. Markanda in Law Pertaining to Arbitration and Conciliation, 9th edition LexisNexis. According to Dr. P.C. Markanda, for the purpose of examining the right of the petitioner to apply under subsection 6 for calculating the period of limitation, it is necessary to establish, in the first instance, the relevant date when the right to apply accrued in favor of the petitioner. It is the date on which the right to apply accrues that determines the starting point. The starting point does not coincide with the date on which the cause of action for filing a suit arises. Whether the claims of a party are barred by limitation or not is for the arbitrator to see, but it is the duty of the court to see whether the application filed in the court is within limitation or not. Limitation for filing application under subsection 4 would commence only from the expiry of 30 days from the receipt of request mentioned in subsection 4 clause A or B, and the limitation for an application under subsection 6 would commence from the happening of the contingencies mentioned in subclauses A or B or C thereof. The procedure prescribed under this section is mandatory, and Article 137 of the Limitation Act providing for limitation shall apply. If the petitioner delays invocation of arbitration clause for months together for no justifiable cause, after the period prescribed in the arbitration agreement had elapsed, the court would not come to the rescue of such a party seeking appointment of an arbitrator, and the abnormal delay of more than a year cannot be condoned. This court in Bharat Sanchar Nigam Limited and another versus Nortel Networks India Private Limited held that The limitation for filing an application under Section 11 arises when there is a failure to appoint an arbitrator within 30 days of issuing a notice invoking arbitration. It clarifies that this limitation period is separate from the limitation period for the substantive claims in the commercial contract. This distinction was also acknowledged under the previous Arbitration Act of 1940. Before moving further, let's first understand Hoffel's theory of jural relations. Hoffel's theory of jural relations is a legal theory that focuses on the relationships between legal rights and legal duties. The theory was developed by Wesley Newcomb Hoffeld, an American legal scholar who lived from 1879 to 1980. Hoffel's theory revolves around the concept that legal rights and duties are not standalone entities, rather, they are interdependent. This means that for every legal right, there is a corresponding legal duty and vice versa. He termed these connections as jural relations, asserting that they form the foundation of the legal framework. Hoffel's dissatisfaction with the premise that all legal relations may be reduced to rights and duties led to the 8 fundamental legal concepts. This was identified as the most significant impediment to understanding and successful resolution of legal challenges. His notion of jural relations can be explained through the below-mentioned table. Please note that the vertical arrows connected jural correlatives or two legal positions that entail each other, whereas the diagonal arrows connect jural opposites or two legal positions that deny each other. The Apex Code further discusses the determination of the starting point for the limitation period regarding a Section 11 subsection 6 application. It suggests that according to Hoffel's analysis of jural relations, the limitation period begins when the right to apply accrues to the applicant. The court is not obliged to appoint an arbitrator if the application is premature, but once the applicant completes the required steps, the court must appoint an arbitrator. This concludes that the limitation period starts when a valid arbitration notice is sent to the other party and they fail to comply with its requirements. While applying the above dicta in the present case, the timeline of events regarding the issuance of notice for arbitration invocation were as follows. The petitioner sent the notice to the respondent on 24th November 2022, giving them 30 days to respond or nominate an arbitrator. The notice was received by the respondent on 29th November 2022. Consequently, the 1-month period for the respondent's compliance ended on 28th December 2022. The petitioner filed the present petition on 19th April 2023, well within the 3-year limitation period provided by Article 137 of the Limitation Act. Therefore, the petition under Section 11 subsection 6 of the 1996 Arbitration Act is not time-barred. Moving forth, the next question that falls for consideration is whether the claims sought to be arbitrated by the petitioner are ex facie barred by limitation, and if so, whether the court may refuse to refer them to arbitration. While answering to this question, the Supreme Court discussed two categories of issues that may be raised against an application for the appointment of an arbitrator under Section 11 subsection 6 of the Arbitration and Conciliation Act. The first category concerns the power and authority of arbitrators to hear and decide a case known as jurisdictional issues or objections. Examples include objections to arbitrators' competence, validity of arbitration agreement, and disputes falling outside the agreement's scope. The second category involves challenges related to the nature of the claim, such as procedural requirements and limitations, termed admissibility issues or objections. The Apex Court, while clarifying the distinction between the two categories of objections, referred to various judgments, such as Bharat Sanchar Nigam Limited, explained tribunal versus claim test while citing Singapore Court of Appeal in the Swiss Bor Diamond Mines Limited versus Kingdom of Lesotho case, discussed the concept of hopeless claims, cited Vidya Dolia and others versus Durga Trading Corporation case, and discussed eye of the needle test as introduced under NTPC Limited versus SPML Infra Limited. The email communications between the parties regarding pre-existing disputes related to franchise agreements were placed on record, whereby the respondent sent a demand notice to the petitioner seeking payment, to which the petitioner responded by raising the issue of dues related to the ICCR project. Despite further email exchanges, the respondent expressed unwillingness to continue discussions about payments for the ICCR project in an email dated 28 March 2018. Consequently, the petitioner's rights to bring a claim against the respondent were solidified on 28 March 2018, marking the crystallization of the cause of action for invoking arbitration. Although the payment for the course from the ICCR was received by the respondent on 3rd October 2017, the petitioner's right to claim against the respondent became evident only on 28th March 2018. It highlights the settled legal principle that mere failure to pay does not automatically create a cause of action. It arises when the claim is asserted and either denied or not responded to. Referring to the case of Messrs. B and T AG, the court enunciates three principles. The right to receive payment begins upon completion of work. A dispute arises when one side claims and the other denies it, and the cause of action cannot be indefinitely postponed by repeated correspondence. The court emphasizes finding the breaking point when further attempts at settlement seem futile, marking the commencement of the cause of action. The court then lastly discussed the concept of break-even point in the Geo Miller case ruling. Coming back to the facts of the case, the petitioner completed the course in April with confirmation issued on 30th July 2017. Although the respondent allegedly received payment on 3rd October 2017, the petitioner's right to raise a claim only accrued in March 2018 when the petitioner asserted their claim, which was denied by the respondent via email on 28th March 2018. Despite a reminder sent on 29th December 2018, the cause of action remained fixed at 28th March 2018. Ordinarily, the limitation period for raising a claim would have ended on 27th March 2021. However, due to the COVID-19 pandemic, the court excluded the period from 15th March 2020 to 28th February 2022 from the computation of limitation, with the balance period becoming available from 1st March 2022. The effect of the court's order on the petitioner's case was that the balance limitation period remaining on 15th March 2020, which would have ended on 27th March 2021 under normal circumstances, is calculated as 1 year and 13 days. This period becomes available to the petitioner from 1st March 2022, meaning that the limitation period for invoking arbitration proceedings would have concluded on 13th March 2023. The court made its stance clear on when arbitration is deemed to have commenced by referencing the Bharat Sanchar Nigam Limited case. It emphasizes that the period of limitation for issuing an arbitration notice cannot be extended by mere exchange of letters or settlement discussions. Settlement discussions or rejection of a final bill do not exclude time under sections 5 to 20 of the Limitation Act. Section 9 of the Limitation Act specifies that once the time has started, no subsequent disability stops it. It stresses the importance of clear notice invoking arbitration, including the particular dispute, within 3 years from the rejection of a final bill to avoid time bar. In the present case, the notice invoking arbitration was received by the respondent on 29th November 2022, which is within the 3-year period from the date on which the cause of action for the claim had arisen. Consequently, it cannot be deemed that the petitioner's claims are time-barred or dead at the commencement of arbitration. Thus, from an exhaustive analysis of the position of law in the issues, we are of the view that while considering the issue of limitation in relation to a petition under Section 11 subsection 6 of the 1996 Act, the courts should satisfy themselves on two aspects by employing a two-pronged test. First, whether the petition under Section 11 subsection 6 of the 1996 Act is barred by limitation, and second, whether the claims sought to be arbitrated are ex facie dead claims and are thus barred by limitation on the date of commencement of arbitration proceedings. If either of these issues are answered against the party seeking referral of disputes to arbitration, the court may refuse to appoint an arbitral tribunal. The Supreme Court finally concluded that the arbitration petition was not time-barred as it was filed within 3 years from when the respondent failed to comply with the arbitration notice. Since the notice was issued within 3 years of the cause of action, the claims were not inherently dead or time-barred at the start of arbitration proceedings. Consequently, the petition was allowed. Furthermore, the court expressed concern over the absence of a statutory time limit for applications under Section 11 subsection 6 of the 1996 Act, leading to the application of Section 137. It criticizes the 3-year period as excessively long, contradicting the Act's goal of swift dispute resolution. The court suggests that Parliament should amend the Act to establish a specific limitation period for moving the court for arbitrator appointment under Section 11, aligning with the Act's aim for expeditious arbitration proceedings. Thank you for watching the video. If you're enjoying the content, please like and share the video with others in the legal community. Do subscribe this channel for more informational content.